How to avoid problems admitting evidence into family court. Do you have a family court case that's coming up? Maybe it's a divorce case, a child custody case, kinship guardianship case. It's a family law case, and you have evidence that you need to get into court. There are some major things that you're going to need to avoid in order to get that evidence into court. Now, first, review all of your orders. Do you have an order that requires you to provide the evidence to the other party and to the court within a specific amount of time? Maybe it states you have to provide it within 10 days. The usual rule is 48 hours, but look at your order and see, is there a specific rule that you need to follow? If so, you need to follow that order. If you don't follow the order, you may not be able to get your evidence, including exhibits or witnesses, into your case. Now, second, you're going to need to file a witness and exhibit list. The witness and exhibit list is going to list what exhibits you plan on presenting, as text messages, phone calls, videos, whatever it is. Your witness and exhibit list needs to list the exhibits and also your witnesses. Your witness's name, their phone number, their anticipated testimony. It needs to list those. If you don't file a witness and exhibit list on time, then the court could prevent you from introducing your exhibits or your witnesses. Now, next, you're going to need to be aware. There's hearsay in family court. Family court doesn't let hearsay in. That's an out-of-court statement made by a party that's not present or a party to the case. So if a party to the case is your ex and you can bring up statements that your ex told you because they're a party to the case. They're a party opponent. Now, if a child made a statement to you, you can't get that statement in because that's hearsay. They're not a party to the case, and the other side has a right to cross-examine them. Likewise, if it's a statement by a mailman, a priest, Scooby-Doo, anyone outside of the case, you can't get that in unless they're there to testify. An exception to this that sometimes works in family court is if it's an excited utterance. So if there's a statement made by a child like, that black dog came out of nowhere and it bit me on my leg, then that could be considered as a excited utterance. Or something like, the blue car ran over my foot out of nowhere. That could be an excited utterance. So maybe you can get in the evidence, the statement, by saying, when they object hearsay, by saying that it's an excited utterance. That's what you need to consider by getting evidence in New Mexico.